Why the RRN standards do not apply to schools, as per the Mental Health Unit Use of Force Act 2018 and the statutory guidance. I recently had a phone call with someone from a withheld number who didn't want to tell me their name, but the conversation went as follows. Hi Mark, I've just been on a training course where the trainer was heavily pushing and promoting the RRN (Restraint Reduction Network) standards, and said that all schools in the UK need to comply with the RRN standards, and that any training done in schools can only be done by a BILD certified trainer who is registered with BILD in the RRN. Surely this can't be right. I currently train in schools, and the training I deliver is fit for purpose. It has reduced restraints and is being delivered in line with a competent assessment of risk and training needs analysis. The training is also regularly monitored and reviewed and adapted and changed as and when the need arises, and we can evidence the rationale for any changes and amendments. My fear is that we are being coerced, bullied for want of a better word, in having to go down the BILD RRN route, which could mean we could lose business merely for the sake of our clients, who also don't want to have to use a trainer certified with BILD and signed up to the RRN standards, just for the sake of having to get a tick in the box. I've checked against the statute and the statutory guidance, and I cannot see that schools are subject to the RRN standards, but I'd appreciate your opinion on this as to why a trainer would push such incorrect or misleading information at us. My response is as follows. There has been a lot of emphasis by various parties, including some training providers, to encourage organisations to comply with the RRN Restraint Reduction Network standards, when clearly they do not need to do so. In some cases, this is for nothing more than to generate business for themselves at an expense, and in some cases at very high and unnecessary financial cost for the organisation, which is an unnecessary financial burden, especially during the current recession and increased cost of living crisis, not to mention the deepening mental health recession, see the Financial Times article, there is a deepening mental health recession, In other cases, it may simply be because the person pushing organisations to adopt the RRN standards is either misinformed or has not done their own due diligence as to what the statute and statutory guidance actually state, and are merely just repeating incorrect information told to them. Where the confusion has possibly come from. On the RRN website, when referring to the RRN standards, it states, "It is important that they are applied consistently to services across education, health and social care, children and adult services across the UK and internationally for all populations, including people with mental health conditions, dementia, learning disabilities and autistic people, in order to consistently minimise the risk of physical and psychological harm to all people in all settings in all nations in the British Isles." However, the Mental Health Unit's Use of Force Act 2018 statutory guidance, the government response to consultation, published on the 7th of December 2021, states, and you can see this on page 6 of the document, some respondents raised concerns around the type of settings the Act applies to and have made suggestions that the Act should apply to accident and emergency (A&E) departments and Section 135/136 suites. We understand the concerns raised with the use of force in different settings. However, they remain out of scope of the Act, which only applies to mental health units that provide inpatient treatment. On the RRN website, it also states that Use of Force Act Statutory Guidance 2021 states training providers must be certified as complying with the RRN training standards. However, what the Mental Health Unit's Use of Force Act 2018 statutory guidance actually states is, and you can see this on page 43 of the statutory guidance, when commissioning a training provider, NHS trusts and commissioned services therefore need to ensure that training is certified by a UCAS accredited body as complying with the RRN training standards. This will help to ensure training complies with the requirements of Section 5 of the Act. And a point to note here is Section 5 of the Act refers to each mental health unit in England. Therefore, the RRN standards only apply to a mental health unit in an NHS hospital in England and as detailed by the very limited categories set out in the statutory guidance. The RRN standards do not apply anywhere else. Therefore, with the help of a very eminent lawyer, I have put together a template letter that you are welcome to download and use as a way of demonstrating that you do not need to comply with the RRN standards. You will of course have to justify via your own training implementation that you do have training in place that is fit for purpose, and the letter, which is also available for you to download and use from the link on this video, is as follows. Firstly, a disclaimer. All of the information provided below has been researched and checked by us. It is accurate at the date of publication. However, it is your responsibility to do your own due diligence and check the following out for yourself to ensure that it is still current and correct should you wish to use all or part of this document. NFPS Limited accepts no responsibility for any use or publication of this document by any third party. Perhaps the approach to take if an inspector, trainer, or anyone else advises you that you should be complying with the RRN (Restraint Reduction Network) standards is to advise them of the following. As a XYZ organisation, we are outside of the scope of the very limited categories set out by the Mental Health Units Use of Force Act 2018 and the statutory guidance issued by the Secretary of State for Health and Social Care under Section 11 of the Health and Social Care Act 2012. Therefore, we are not legally required to comply with the RRN (Restraint Reduction Networks) standards. For clarification, the categories that must comply with the Mental Health Units Use of Force Act 2018 and the statutory guidance are, as taken directly from the statutory guidance, are: mental health unit is described as a health service hospital or independent hospital in England or part thereof that provides treatment to inpatients for a mental disorder. An independent hospital or part thereof will only be a mental health unit if its purpose is to provide treatment to inpatients for mental disorder and at least some of that treatment is provided or is intended to be provided for the purpose of the NHS. The types of inpatient service which will be considered within the definition of a mental health unit (this is not an exhaustive list) include acute mental health wards for adults of working age and psychiatric intensive care units, long stay or rehabilitation mental health wards for working age adults, forensic inpatient or secure wards, low, medium and high, child and adolescent mental health wards, wards for older people with mental health problems, wards for people with autism or a learning disability, specialist mental health eating disorder services, inpatient mother and baby units, acute hospital wards where patients are detained under the Mental Health Act 1983 for assessment and treatment of their mental disorder. The following services are considered to be outside of the definition of a mental health unit (this is not an exhaustive list) and therefore not covered by the requirements of the Act. Accident and emergency departments or emergency departments, Section 135 and 136 suites that are outside of a mental health unit, outpatient departments or clinics, and mental health transport vehicles. They're outside the scope of the Mental Health Units Use of Force Act and the statutory guidance. Outside of the very limited categories where the Act and statutory guidance applies, we have heard that other services are being encouraged to have their training certified by Build as complying with the RRN training standards. There is no requirement for us to do so. Also, as a school, we are not bound by the conditions of the NHS standard contract. However, even if we were, we are aware of the following provision that creates an exception not to adopt the RRN standards. Section 41 of the NHS Standard Contract 2021-22, and as I'm recording this video, I understand this contract has now been updated. Technical guidance (mandatory service development and improvement plans) SDIPs. Section 41(6) also makes it very clear that the intention of mandatory SDIPs (Service Development and Improvement Plans) is not to require significant additional investment from commissioners or providers. Rather, it is to encourage joint management action to tackle important priorities to the extent possible within available resources. Therefore, even if we were considering voluntarily having our training certified by Build as complying with the RRN training standards, we are aware of Section 41. The reasonably practicable argument, cost versus risk, Our training provision is based on the training control measures identified in a suitable and sufficient risk assessment, as required under health and safety legislation, This means that the training we provide has been justified on a risk versus cost basis. Therefore, we feel that adoption of the RRN training standards would A. reduce compliance, B. be an additional unnecessary expense, C. possibly be detrimental to staff and service user safety, D. possibly even breach health and safety legislation by making us train outside of our risk assessed training provision. And there is a link where you can download a copy of the letter here, which is the letter re-RRN compliance (final) below this video. So underneath this video, there'll be a link somewhere that you can download the letter that contains everything I've just told you. Finally, if a trainer or any other person is knowingly pushing you to comply with the RRN standards and/or only use a Build certificated trainer when you don't need to do so, that is called misrepresentation. There are three types of misrepresentation, as defined by the Misrepresentation Act 1967, which are fraudulent misrepresentation, where a false representation has been made knowingly or without belief in its truth, or recklessly as to its truth. Negligent misrepresentation, a representation made carelessly and in breach of duty owed by party A to party B to take reasonable care that the representation is accurate. And innocent misrepresentation, a representation that is neither fraudulent nor negligent, but which would infer that the person advising you is incompetent, and therefore why would you use someone who hasn't done their own proper due diligence anyway? The remedies for misrepresentation are rescission and/or damages. For fraudulent and negligent misrepresentation, the claimant may claim rescission, in other words, cancel the contract or agreement, and is entitled to a claim for damages. For innocent misrepresentation, the court has a discretion to award damages in lieu of rescission. The court cannot award both. See Section 2, of the Misrepresentation Act 1967. So if a trainer or anyone else is giving you incorrect information, especially if they are doing it intentionally and for the purpose of financial gain, you can cancel the contract, refuse to pay them, and take them to court for a breach of the Misrepresentation Act 1967. I hope that helps.